My Lord, I would like to start by the seriousness of this matter, that the second respondent, the fifth and the sixth, to show the unseriousness that they have, my Lord, they have not even taken even a single statement from the family members of the second petitioner. My Lord, and they are present before you as we speak. My Lord, to speak to the writ of habeas corpus in a case of Etrelita de Martinez versus Director General and others, that is in Philippines, and the case which was cited with approval in the case of Masood Salim Hamed and another versus the Director of Public Prosecutions, they defined habeas corpus as generally applies to all cases of illegal confinement or detention by which any person is deprived of his liberty or by which the rightful custody of any person is withheld from the person entitled thereto. In another case, this court said that the ultimate purpose of the writ of habeas corpus is to relieve a person from unlawful restraint. It is devised as a speedy relief from unlawful restraint, my Lord. And therefore, this writ of habeas corpus is unlimited under Article 25, whatever the circumstance or whatever the situation. My Lord, as I conclude, the architects of our Constitution sought to address a historical concern, and the survivors of the Nyayo regime, my Lord, endured a very brutal police force that held them incommunicado without trial. And even during that time, my Lord, in the case of Karanja, who was detained without trial and later on murdered, was exhumed and the body was recovered for the families to see. So it means, my Lord, that even during the Nyayo era was better than the era that we have, because at the moment we cannot even get a body that we want. So it is my prayer, my Lord, that this court stamps its authority and help this nation secure justice. Because, my Lord, despite the fifth and the sixth respondents not being present in court now, we are patient to even wait for them in the afternoon. Because yesterday, according to the presser that the DCI director issued, he said that he would be in court today.
The Inspector General of Police and the Director of Criminal Investigations were named as the first and second respondents, and also the fifth and sixth respondents in their personal capacities are hereby directed to produce Ndiangui Kinyagia, the second petitioner, in court tomorrow, the 1st of July 2025. In default, the Inspector General of Police and the Director General of Criminal Investigations do attend court to show cause why Ndiangui Kinyagia, the second petitioner, should not be produced in court or released. It is clear, my Lord, that in the absence of Ndiangui Kinyagia being produced in court, the Inspector General of the Police, the first respondent, and the Director of Criminal Investigations, the second respondents ought to be here before you. Nothing whatsoever has been said about their blatant disobedience. There's nothing in the replying affidavit of the respondents of Samuel Itegi to tell us how far they have gone with the investigations and what they have done in Kinyagia. This matter has been very, very public. That yesterday, my lord, the DCI, the second respondent, at 4 p.m., long after you had adjourned the hearing and given your orders, therefore we assume that he knew he's supposed to be in court today, decided to appear before the public and deny having Ndiangui Kinyagia in his custody. So he will deny publicly, but he will not come to assist the court to reach a decision. And he will deny publicly in a matter that is sub judice. A very, very disturbing feature of the affidavit of the respondents is to be found in their annexure, their sole annexure to their replying affidavit, which is the police, the inventory of the things taken from Ndiangui Kinyagia science. It's page 10 and 11. If you look at that, my lord, and look at our annexure attached to the affidavit, further affidavit of Florence Muturi, sworn on the 27th day of which was Monday, where we attached as FM1 the inventory taken of items taken from Ndiangui's house. You will, on the face of it, discover that the annexure SI1 of the replying affidavit of the respondents appears to be a forgery. And which makes the second respondent.
Which one are you referring to?
I would request that my lord has both of them. The one attached to the respondent's replying affidavit, the first page, and the one attached to our further affidavit, floor FM1. Ours is in color. Theirs is in black and oh, I'm told it's also in black and white. It's my copy that is in color. If you look at those two, my lord.
Just give me a minute.